The theory that the courts would enforce any clause where the parties had made clear their intentions was really tested to its most extreme in the case of Union Eagle and Golden Achievement, which is a Privy Council case. In that case, Union Eagle had paid a deposit of 10% to Golden Achievement for the purchase of an apartment. The contract was to be concluded on a particular day at a particular time, at which the remaining 90% were due. The contract stated very clearly, firstly, that it was of the essence that payment was made on time. Secondly, it stated that the innocent party, in this case Golden Achievement, was entitled to terminate the contract if payment was late. In the event, payment was 10 minutes late. The value of the contract was more than $500,000 US. Golden Achievement terminated the contract due to the lateness. Union Eagle brought an action alleging that it was unconscionable to enforce the clause, even though both parties had agreed as part of this clause that it was a condition that payment had to be made on time. The Privy Council held that since the parties had made their intentions very clear by way of their contract, namely in two ways. First, they had stated in their contract that time was of the essence. Second, they stated what would happen if there was a delay, namely that the innocent party could terminate. Given that the parties had stated their intentions so clearly that they had obviously been in agreement as to this particular clause, the court did not find it appropriate to intervene and somehow undo this clause. The Privy Council specifically stated that there was a need for certainty in the business world. And it follows, therefore, that where parties have agreed their terms and where those terms are clear and their intentions are clear, it is not the role of the courts to intervene. And therefore, Golden Achievement was absolutely entitled to terminate the contract, and that was the end of the matter. Another way of looking at this case, which really only underlines the Privy Council's decision, is if we were to allow parties to be late, even where they agreed not to be late, how late is okay? Is 10 minutes okay? Is 1 hour okay? Is 1 day okay? Well, why are the courts supposed to make that decision when the parties have already agreed on their intentions and they've already agreed what will happen in case there's a breach? So again, this only supports the Privy Council's holding. Remember, all of these discussions take place in the context of freedom of contract. The freedom of all persons, all individuals, companies, anyone to freely contract with other parties on terms that they themselves determine. And clearly in Union Eagle and Golden Achievement, the parties freely determined what those terms were going to be. And so the only role left to the court was to enforce those terms. The best way of ensuring that a court will enforce something that the parties intended to be a condition is to stipulate both that the term is of the essence, as well as the fact that a breach allows for termination. Bunge and Trade Acts is a good case to demonstrate this. It is a fairly complex case, but for our purposes, what is important is that Trade Acts was going to nominate a port, and Bunge was not going to nominate a ship, and certain goods, in this case soybeans, were going to be delivered to that port which had been nominated by Trade Acts, and they were going to be loaded on a ship which was to be nominated by Bunge. Bunge had to give Trade Acts advance notice of whenever the ship would be ready for loading. Advance notice was defined as 15 days. In the event, Bunge was late by 4 days. Trade Acts terminated the contract and Bunge sued. The House of Lords held that as the term was stated as a condition, the courts must treat it as a condition. Therefore, Trade Acts' termination was valid. Note that the presumption that the word condition actually means condition applies where lawyers drafted the contract. And again, we can refer to Schuller and Wickman for this. Now, this does not mean that the presumption is not rebuttable, but nevertheless, when a contract, which has been drafted by lawyers, mentions the word condition, we have to presume that that is what was meant by the parties. In Schuller and Wickman, Lord Reed as well as Lord Simon clearly stated this rule as it applies to contracts drafted by lawyers, but at the same time they found that in the event that presumption had been rebutted in that particular case. So what happens when the parties agree on a deadline and agree that the deadline is an important factor in the contract, such as stating that such and such goods must be delivered by such and such time, but they do not specifically mention that termination may ensue where there's a breach of such a deadline? Well, as Bezadi and Shaftesbury Hotels shows us, a party to a contract where it has already been agreed that time is of the essence may, even after the contract commences, even after the contract has been agreed, stipulate that where there's a breach of this deadline, the contract may be terminated. One final point to be noted, perhaps along the lines of Union Eagle and Golden Achievement, looking at cases on the extreme. We can look at photo production and Securicode transport. This case shows us, once again, where the parties have clearly stipulated what their intentions are, where those intentions are clearly manifested in the contract. The courts will not interfere and undo whatever the parties' intentions were. In photo production and Securicode, Securicode was responsible for looking after photo production's facility. An employee of Securicode, who was on duty one evening, felt cold, so he started a fire. Unfortunately, the fire started to spread and photo production's factory burned down. There was an exclusion clause in the contract between photo production and Securicode, which in essence stated that Securicode was not responsible for these types of incidents. Specifically, the contract between photo production and Securicode stated that Securicode would not be responsible for any damage or loss which was caused by an employee, but for which Securicode was not responsible because it could not have foreseen such an event. Photo production argued that because the breach of contract, specifically that Securicode was hired to look after the factory and ended up burning it down, because this was such a fundamental breach, it invalidated the exclusion clause. The House of Lords, in overruling Denning, who sat as a Court of Appeal judge on this case, stated that the exclusion clause was valid. It held that exclusion clauses are to be construed just as any other clauses of a contract, and where the parties' intentions are clear and they're manifested in the contract itself, the court's role is to enforce those clauses. Thus we are left with the basic rule that the courts will enforce a condition if the party's intentions are clearly manifested. The best way of manifesting a party's intention is to, number one, state that a clause is of the essence, for instance, by using the word condition, and secondly, to make it clear that in case there is a breach, the innocent party may terminate. As long as those two things are done, the courts will enforce the condition. Let us move on now to warranties, or breach of a warranty. Warranties are minor terms. They are not central to forming of or operation of a contract. And we've already looked at the case of Bettini and Guy to illustrate this. Recall that Mr. Bettini had only missed rehearsals. He hadn't missed any actual performances. And the court held that therefore, the type of breach that Bettini had committed was not one that allowed Guy to terminate the contract. Now, the UK Sale of Goods Act in 1893 clarified that distinction between conditions and warranties, whereby conditions are such terms that allow the innocent party to terminate, and warranties are terms which do not allow the innocent party to terminate, although they can claim damages. This distinction was adopted by the House of Lords in the case of Wallace Sons and Wells, Pratt and Haynes. This essentially left the law of contract with two possibilities in respect of a breach. A breach could either be a breach of a condition or a breach of a warranty. In other words, every term of a contract would have to fit into either one of those molds. It would either have to be a condition or it would have to be a warranty. This position changed in 1962, which saw the case of Hong Kong Fir Shipping and Kawasaki Kaisen Kaisha, which we can simply refer to as Hong Kong Fir, as that was the name of the ship at issue in this case. The term at issue was the term seaworthy. The problem with this term is that seaworthy can be essential or non-essential. It really depends on the circumstances. It depends on the facts. Here's how Lord Diplock put it. As my brethren have already pointed out, the ship owner's undertaking to tender a seaworthy ship has, as a result of numerous decisions as to what can amount to unseaworthiness, become one of the most complex of contractual undertakings. It embraces obligations with respect to every part of the hull and machinery, stores and equipment, and the crew itself. It can be broken by the presence of trivial defects easily and rapidly remediable, as well as by defects which must inevitably result in a total loss of the vessel. In other words, whether a ship is seaworthy can refer to minor issues such as whether there's enough equipment on board, or very major, very essential issues such as whether the ship is about to sink. The trouble is that this is not known, in fact it is not knowable at the time that a contract is concluded. So where the parties merely agree that a ship must be seaworthy, unless and until we know about the breach, we don't know how serious it is. For this very reason, the court held that the term seaworthy in Hong Kong Fir was neither a condition nor a warranty. In the event, the chartered ship, the Hong Kong Fir, which had been chartered for 2 years, had to undergo repairs which lasted for a few months. Lord Diplock held that this was not serious enough to warrant termination of the contract.